The topic is, accomplice liability, and as always I plan to go into various details, but I think that I'll be very egoistic here, and having you here, I will probably end with some general remarks and problems that I see even more as a practitioner dealing with corporate crimes and international organization, not even the very ICC itself, but seeing a lot of similarities. Just as a brief remark, you know, if some of you don't know, there's such a thing as the ICC statute and its preamble. Yes, and the preamble puts, at least in 3 elements, a really strong emphasis on the obligation to exercise criminal jurisdiction responsibility over all the people responsible for committing crimes. Yes, just let me mention those 3 very strong affirmations that we as international community affirm that the most serious crimes must go unpunished, that we are determined to put the end to impunity for the perpetrators, that recalling that is the duty of every state to exercise criminal jurisdiction over those responsible for international crimes. Now, so the obvious basic question is who is to be held responsible? Yes, whom should we put on trial and whom should we punish? And really that's not an easy question, not only from the evidence point of view, but strictly from the legal concept and its judicial definitions. Yes, please allow me a simple explanation. Yes, the ICC, international cooperation, a lot of struggling on different judicial approaches, traditions, politics often, which has to be somehow overlaps in such a marvelous way as it was yesterday discussed. Yes, and that's a really high level. But even on the domestic level of almost every jurisdiction, we have enormous problems with defining whom to hold responsible for organized crime. And certainly war crimes is a type of organized crimes. Yes? Dealing with transborder cases, white-collar crimes, I can confirm that it's really hard to identify the real perpetrator, the indirect perpetrator, whether there is already an involvement as a perpetrating or only aiding to commit a crime. Yes, I understand that it's a concurring opinion. Please let us remember that we have to analyze and define all the notions of perpetration. We also have to bear in mind the problem of assistance in committing crimes. And at the end, we have to also look at the other leg, the other stem of the problem, whether to penalize the mere involvement of certain activity. As for the help, aiding, and so on, we've got the Article 25C, just to remind you, and putting emphasis on the idea of assisting by providing means to commit crimes. Now, I think that it's really up-to-date issue now, since we have obvious problems with exercising responsibility for some of the, at least as the major conflict we have now going on. Now, but there are a lot of entities involved and collecting a lot of money in that conflict. What should be proven to them? We have some jurisdiction over the responsibility over arms dealers. Yes? Now, there are people who have money, there are people who have a lot of lawyers, there are people who know how to avoid responsibility. Of course, in certain situations, they may be held responsible before the national courts. In some, not. If you like movies and if you like some analysis of some political deals, you know that recently one of the most famous, historically, arms dealers was released from prison, perhaps to some actual needs. What should be proven to arms dealers if you wanted to hold them responsible under 25 3 letter C? Yes, what type of mens rea should be proven to them? That they knew specifically that we will sell guns, tanks, whatever, to commit specific war crimes in this city to those people, or did they have a general notion to whom they sell the weapons? Now, in present times, you don't have to meet in the middle of the jungle and get a load of cash. You may sell certain items in dark web and get money through bitcoins, yes? If you intentionally avoid going into details whom you support, can we still think and define it as fulfilling those mens rea requirements to put the responsibility under Article 25 and assisting by providing means? Yes? So the first element of possible responsibility is the responsibility for being the perpetrator or some type of a helper to commit crime. Now, but what's the other stamp? The other stamp is a thing that in national jurisdictions is used quite often, and it was used as a mean to fight the organized crime in situations when we don't have evidence to go into very details. When we cannot prove that someone directly or indirectly committed certain act, certain crime, whether we may punish him for being a member of certain organization. Yes? So, do we have elements of such responsibility before the ICC? Well, we have the specific structure of Article 28. If the time allows, I think not, we may go into details there. Yes, of being a commander, of a person effectively acting as a commander. Yes, a commander from the highest level to the lowest level. Yes, also going into details how to define this military character of someone's actions. So at the very beginning we have those two pillars, thinking stemming from this what's in the preamble, that the major issue and the major requirements is not to allow people involved, people responsible, to omit responsibility. Yes? And as lawyers, what can we act? Yesterday we had a marvelous discussion over the requirements of precise definition of the ability of acting by the court in a manner of common law courts within the frames of Article 22.3. Now, there's Article 22.3, yes, the precise definition of a crime. Deals only with the definition of a crime? Or can we be more flexible on Article 25 and analyzing the scope of the people involved? Or can we agree that Article 25, along with Article 28, create a sufficient, very broad basis for putting people before the tribunal who are really responsible for committing those crimes? So I think that a lot of problems with analyzing legal cases also come from this thing that we come from not only from different legal traditions, but none of us have the real idea how the international war crimes look like, having only an experience of the crimes we know domestically. Yes, and I'm quite certain that international criminal jurisdiction is putting individuals responsible for always more or less collective wrongdoings, yes? And those collective wrongdoings are always large-scale offendings. And very often, the distance between the accomplice and the harm is really great in comparison with ordinary crimes, yes? Of course, someone may order to shoot somebody, but there are two people, yes? Well, what in situation there is a chain of command or chain of supporting, using also the middleman committing such war's crime, yes? Whom to put responsible for those actions, yes? So culpability here should be assessed always in relation to the actions of other perpetrators, of course, discussed whether where one's responsibility ends according to another. Just a brief reminder, yes, the basic notions, we all know them, the notions of control of a crime. There is no discussion that now we have full recognition of the importance of holding accountable those who not physically perpetrate the crime or in some other way assist, but who stand in the very top of the decision. Yes, and the complicity as a notion born from the national legal systems shall be understood to embrace all those models of participation apart from the strict notion of committing a crime. Yes, we also know that as the Article 25(3)(a), it's this idea seen in the Polish criminal code, in the German criminal code, all those three varieties of perpetrations are included. Yes, direct, and indirect, and co-perpetration. Yes, and what's important is that in interpreting those provisions, ICC has consistently rejected both the only objective and the only subjective perpetration, referring to the concept of the control of a crime. Yes, which assumes that the perpetrator of a crime is a person who exercises the authority over the act committed. And what is important, and what I think is cheering, if I may use such a word, towards such dramatic situations, is that the detailed analysis of the ICC jurisprudence indicate that the essence of the concept of the control of a crime is not so much control over the commission of the act itself, but over the process of realizing its, not even the process of realizing its elements, but over the organization itself. Yes, the organized hierarchical structure that was used to commit the crimes. And once more, good tendency, but how does it go along with the requirements to be precise, to recognize the mens rea, and not to go very blind in such decisions. Now, we all know about Article 28, and there is this broad discussion, yes, whether Article 28 creates a form of subordinate complicity, or whether that's a provision that only sets the prerequisites that allow the imputation of criminal responsibility to a military or civilian commander for an act carried out by its subordinaries. As I stated at the beginning, in Article 28, I see some kind of reflections of those domestic regulations that punish mere involvement in certain organizations. I understand that obviously you cannot define the acts of war generally, the international criminal activity, always by putting every people into one basket. Yes, you cannot state that the mere fact that someone was in an army makes him responsible. Yes, that wouldn't make the responsibility effective. But under Article 28, as I already stated, we may go very large, very broad, and very narrow in defining this responsibility for people acting under your orders. Now, essential contribution, I really like it. Just bearing in mind the time frame, just let us remember that ICC jurisprudence repeatedly states that it's not necessary that each of the conspirators personally exhausted at least some of the elements of the crime. Yes, nor that he was present at the scene of the act, provided that it is shown that he exercised joint authority over the acts of other people. And the thing is that this authority manifests in the necessary contribution to the implementation of the agreement, creating the basis of the activities. Yes, and from this point of view, this involvement in the agreement also does not have to include very detailed elements. This agreement does not have to concentrate merely on the international crimes. It's enough to have its elements, which is also, I think, good for putting as broad responsibility as possible. Now, I would love to go into details analyzing the cases in Bemba and Lubanga and distinction between a participle actor, accessorial actor, and so on. Yes, bearing in mind that the time slightly ends. Wow, just it's like 1/3 of the things I'd like to address as only the general issues. I can end with quoting this quite famous statement that the factual scenarios presented in the sphere of international criminal activity, yes, doesn't, I think, practically allow us to draw a bright line that would allow to distinguish between all the categories from the Article 25. Now, the question to be answered is whether we necessarily need always to create this very specific legal qualification between each type of perpetration or action, or whether the frames we use jointly under Article 25 and 28 are sufficient to realize those aims that are drawn in the preamble. In my opinion, they are sufficient, but I think that especially this what happens now in the modern world, this what might be organized remotely, without personal context, especially as we speak about supporting international criminal actions, require active interpretation of those terms, and this approach towards mens rea that I think is closer to the continental approach than the common law one. I promise to be more clear, less speaking about fiats in my written article. Thank you very much.